We often hear that slavery in the antebellum South was brutal, and let's be honest, it was. But what about the law? Did the legal system offer any protection to the enslaved? Did it place any limits on the power of the enslavers of the masters? The reality is far darker than many of you may imagine. While some laws claim to shield the enslaved from abuse, they were nothing more than a facade. They were crafted not to protect the enslaved, but to preserve the power and control of the enslaver. These so-called protections were riddled with loopholes, rarely enforced, and ultimately served as tools of oppression disguised as justice. So today we're going to look at the foundations of this legal system and expose some of its horrors. To do this, we're going to look at The Laws of Negro Slavery in the United States of America by Thomas R.R. Cobb. Now, to give you some background, Thomas R.R. Cobb was known affectionately by Confederates as the James Madison of the Confederacy, because he was instrumental in the crafting of the Confederate States of America Constitution. He also compiled this legal treatise on the laws of slavery in all of the slaveholding states. He was a well-respected jurist in the state of Georgia, and his brother, Hal Cobb, at one time was the governor of the state of Georgia, the Speaker of the House of Representatives, and I believe the Secretary of the Treasury. So this family was well known in the antebellum South, in the slaveocracy. And he wrote this book in order to help attorneys who were practicing in front of slaveholding courts if they needed any sort of information to support their case, or if they needed to look at case law, or anything concerning any of the laws around slavery in the slaveocracy in the antebellum South. So this is a primary source that was used and even cited by many courts in the slaveholding states. So in a previous video, and you should go back and watch, I explained that Thomas Cobb made the argument that there was no requirement for a positive law for slavery to exist, meaning that you did not have to open the Code Book of Georgia and for it to say you can have slaves in order for the enslavement of Africans. He made this argument because he claimed that slavery was the natural condition of Africans and people of African descent, and their subjugation, their enslavement to the Caucasian race was, again, their natural position, where they were supposed to be, because it benefited and it was positive to their nature. It was good for them because they were physically built for slavery and they were intellectually inferior to the Caucasian race. So let's look and see what Thomas Cobb says concerning the foundation of any law that was meant to protect the enslaved. So he writes in chapter 4 of The Laws of Negro Slavery in the United States of America that the condition of these slaves in their native country, having been one of absolute slavery, including the power over life, such would be their condition in the country which they were removed, except so far as the same may be modified by the existing laws of their new domicile, and such subsequent legislative enactments as may have been made for their benefit. The law of nature, denying the power over life and limb, being a part of the law of every civilized state, such power never existed in any of the United States, although it required municipal law to prescribe the punishment for such offenses. So what was he saying here? I'll continue reading because he'll support his argument, but what he's saying is that when Africans came here as slaves, they came in a state of absolute slavery. Absolute slavery meant that the enslaver had absolute control over the life and limb of the enslaved. They could do anything they want as the master over this enslaved. And the only limits on the powers of a master in what would become the antebellum slaveocracy would be if a state legislature prohibited a master from doing something. So, in effect, what he's saying, if the state governments didn't prevent a master from doing something to a slave, then a master had every right to do something to a slave. But if you notice, right at the end there, he did throw in a little loophole. And again, this is where we watch the mental gymnastics of the jurist in the antebellum slaveocracy trying to justify slaves being both persons and property. What he said was, although in civilized societies, the law of nature, and remember, he justified slavery by saying the law of nature is anything that does benefit to someone's nature. So slavery is good for Africans because it takes them out of barbarism, it civilizes them, it educates them, and it's what they were built to do. However, if you could just kill someone or cut off their arm, how could that better their person? How could that be good for the law of nature? So we had to put a caveat in here and say, yes, even without the legislature could say nothing, there still is one limit on the power of a master, and that is the power over arbitrary life and limb. So you couldn't just kill your slave or cut off their arm, because that would go against the law of nature. It wouldn't benefit them. But we'll see in later lessons how they actually got around this when it came to punishing slaves. But that's it in a nutshell. He goes on to say, many subsequent legislative enactments have been made regulating the power of the master and protecting and giving rights to the slave. Having none prior to these enactments, to the municipal law we must look for all of his rights. So what he's saying is that unless the legislature gives a right to an enslaved, they don't have it, and a master has any power over a slave unless the legislature of the state limits it or prohibits a master from doing such a thing. He even said in there, if you caught it, that even though you couldn't kill or maim a slave, unless the legislature put a punishment in there expressly for a white person or a master who were to maim or cripple a slave, there would be no punishment for it. So in a nutshell, without positive law restricting the power of a master over the enslaved, a master, according to Thomas Cobb, could do anything he wanted to an enslaved individual. So now we're going to see where they have to tap dance and do mental gymnastics around this idea of slaves being both persons and property. Because he says, one of the three great absolute rights guaranteed to every citizen by common law, such as the right of personal security, the right of personal liberty, and the right of private property, the slave in a state of pure or absolute slavery is totally deprived. As a totally deprived being, as to life, liberty, and property under the absolute and uncontrolled dominion of the master. So again, what he's saying is that common law, which is the unwritten law that applies to all people, all citizens, doesn't apply to slaves here, except what he's going to say when it came to their right to life, to exist as a person. So let me explain what he means by this. And this is where it's going to get even more bizarre. He says the law, by recognizing the existence of the slave as a person, thereby confers no rights or privileges except such are necessary to protect that existence. All other rights must be granted specially. So the only right that the enslaved person has is the right to exist. Any other right has to be granted through legislative enactment. And this is going to be difficult for some people to hear, so a trigger warning if sexual violence is an issue for you before I continue to read, because there's going to be a lot of that towards the end of this lesson. So he says, hence, the penalties for rape would not and should not, by such implication, be made to extend to cardinal forcible knowledge of a slave, the offense not affecting the existence of the slave, and that existence being the extent of the right to which the implication of the law grants. So did you see what Thomas said there? What Thomas Cobb said was that since the only right that a slave is guaranteed without it being expressly written by a legislature is the right to exist, that the rape of a slave is not a crime, and they are not protected from such a crime because raping a slave does nothing to impact their existence as a person. So unless there's specific legislative enactment, the rape of a slave is not a crime. It can't be a crime because they are not protected from that, because under common law, the only protections that they are allowed is the protections of their right to exist. And raping a slave does not take away from their right to exist. So I know that's horrible. And there's no other way around it. It's an evil, evil thing. And we'll circle back around to that at the end. So Cobb goes on, the protection of the person of the slave depending so completely upon statute law, it becomes a question of importance what words in statute would extend to this class of individuals. So what he's saying here is, okay, so if there has to be express law to protect the enslaved, then why doesn't all law just protect the enslaved? If you can't murder, then why can't you not murder a slave? And again, we're going to see where the racial hierarchy and white supremacy comes into play. He says, generally, it would seem that an act of the legislature would operate upon every person within the limits of the state, both natural and artificial. However, experience has proved what theory would have demonstrated, that masters and slaves cannot be governed by the same laws. So different in position, in rights and duties, they cannot be the subjects of a common system of laws. So what he's saying is that no. If on the record books, if in the legal books, it says that you cannot kill another human being, that does not apply to the enslaved unless it clearly shows that this would be a crime against the enslaved. And he says that because in a system of slavery, there has to be two systems of laws between the enslavers and the enslaved. And that's just the natural order of things according to Cobb. And he goes on to explain why the law has to be separate and different. He says it would seem that from the very nature of slavery and the degraded social position of the slave, many acts would extenuate the homicide of a slave and reduce the offense to a lower grade, which would not constitute a legal provocation if done by a white person. So what he's saying is that this law has to be different because a white person killing a white person might not be excusable under the law, but a white person killing an enslaved person, killing a black person, could very well be excused because of the degraded position of the enslaved and the offense that enslaved committed against that white person, causing them to kill them, right? Racial hierarchy, white supremacy. It says, thus, in the State v. Tackett, it was held competent for one charged with the murder of a slave to give in evidence that the deceased was turbulent and insolent and imprudent to a white person. So an assault or striking by a slave would, in many cases, amount to justification of a homicide, which in a white person would only mitigate the offense. So again, what he's saying here is that under this system of laws, there has to be two systems because the whites are superior, the racial hierarchy. They are the enslavers. Africans are the slaves. And there are things that a slave might do to a white person that would justify that white person killing that enslaved, as opposed to a white person on white person violence, which would not be excused under the same law. So there has to be two separate systems of law that regulate or protect the enslaved and that regulate and protect free people. So again, system of racial hierarchy, it is very difficult to read. It's very difficult to go through, but clearly it shows you that, the protections that were afforded to the enslaved was a facade. It clearly was a facade. All of these laws did very little to actually protect any enslaved people. What they did was they existed to continue and maintain the system of white supremacy and to have this racial hierarchy. So I want to finish on something that is going to be very difficult to hear. And again, it comes to sexual violence, to show you how Thomas Cobb believed that masters, and in fact, all white people held a position of superiority over the enslaved, but how masters and their agents could not be held criminally responsible or even civilly responsible for things they committed against the enslaved unless there was positive law to give the enslaved that protection. If there was no positive law to protect the enslaved, then a master could do whatever they wanted to this person. So it says, it is a matter worthy of consideration. Forgive me, let me back up. Another consequence of slavery is that the violation of the person of a female slave carries with it no other punishment than the damages which the master may recover for trespass upon his property. So if a white individual were to rape an enslaved person, there would be no criminal punishment for that unless the legislature made that a crime. The only thing that could happen is the master could sue the person who raped his slave for damages because the enslaved woman was property. That's the first very difficult thing to hear. But it gets worse, believe me. It is a matter worthy of consideration of legislatures whether the offense of rape committed upon a female slave should not be indictable. So he's actually saying, hey, this is for your state governments to decide. And they should consider this. But he says, and whether when committed by the master, there should not be the sale of the slave to some other master. So he's saying maybe the government should look at this, and you start to think that maybe he's thinking, he's going down the right path. But watch what he does here. He says the occurrence of such an offense is almost unheard of, and the known lasciviousness of the Negro renders the possibility of its occurrence very remote. So he then poos all over it by saying, however, while your state government should consider putting on the record books crime for the rape of an enslaved woman, however, we know that that's not going to happen because people of African descent, Africans, are just controlled by their lust, they're animals to their lust, and if a master did have sexual relations with the enslaved, it clearly wasn't rape because that woman, that slave woman, is the one who initiated and did it or wanted it because, their lasciviousness, they're controlled by their lust. So again, this is just the first in many of a video series to show you that the laws that were meant to protect and if they're meant to protect the enslaved, were really just a facade. They were crafted not to protect the enslaved. They were crafted actually to protect and preserve the power and the control of the masters and the enslavers. So as always, remember to like, subscribe, share, and I will see you for the next lesson.